Cortez. Thank you.
You're welcome, Judge.
Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for July 18th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, let's turn on the function and then call our next case. Folks on the English, please select English channel. Annex if you will select Spanish.
Sí, claro. Sí, le escucho.
He can? Okay, great. Okay,
In cause number 2022-0D04696, State of Texas versus Sergio Lopez. Announcement of council, please.
David Vandenberg on behalf of the state.
Mr. Huffman, you're muted, and I don't know if you selected English.
I did, sorry, Judge. Rick Huffman on behalf of Mr. Lopez.
And Mr. Huffman, do you see your client appearing from the jail annex?
Yes, Your Honor.
And Mr. Lopez is appearing remotely, also utilizing the assistance of a court interpreter, Ms. Patricia Hernandez. Mr. Lopez, we are conducting today's proceeding, which is a plea in this case, obviously via Zoom. Have you waived your right to have this done in person?
No. Que se haga de una vez en video.
Okay, so you are consenting, or you agreeing to do this over Zoom?
Sí.
Okay, Mr. Lopez, in order to get started with your plea, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Sí.
Go ahead and put your hand down. Please state your name and date of birth for the record.
Sergio López. Marzo 16 de 91.
Mr. Lopez, as I mentioned, I received documents indicating that you intend to plead guilty in this case. The first document is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Lopez, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Sí.
Did you understand everything contained within that document?
Sí.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, Your Honor.
Mr. Lopez, are you satisfied with your attorney's representation of you?
Claro. Sí.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Lopez, have you ever been found mentally incompetent by any court?
Sí. Pues en realidad no entiendo esa pregunta.
So has a judge ever said or issued an order saying that you did not have the mental ability to handle your personal affairs?
No sé. Sí, no sé.
Do you recall when that was?
No recuerdo.
Mr. Huffman, has your client had competency issues in the past?
I was not aware of that, Judge. I've had a few discussions with Mr. Lopez. He hasn't had any difficulty understanding the facts of the case, the laws and the roles of each person. And I don't think he's had any problems understanding anything that we've talked about. And I believe he's got a rational and factual understanding of the facts and the law of the case. Yeah, I don't know if he understands the question, Judge.
Right. Mr. Lopez, has there ever been a point in your life where some other person has had to handle your personal affairs because a judge or a doctor says that you don't have the mental capacity to do it?
No, ya no tengo ningún problema con eso. Entiendo todo claramente. Entiendo los derechos que me dijeron, todo lo que ha hablado con el abogado, todo lo he entendido bien. Recuerdo todo.
Okay. Okay. Is there any condition that has been diagnosed in the past or anything that you're feeling right now that prevents you from understanding what we're doing today?
Entiendo todo claramente.
Have you been able to communicate with your attorney, Mr. Huffman, effectively?
Sí, claro que sí.
Okay. Mr. Lopez, what kind of education do you have? Did you go to high school, college, anything like that?
No fui a la escuela.
All right, Mr. Huffman, I think I understood your representation that you have had no concerns regarding your client's competency.
None at all. And I don't think he's even has a mental health diagnosis. He's fine, Judge.
Mr. Lopez, do you have any type of diagnoses? You don't have to tell me what they are. Any mental health diagnoses?
Dígame. Claro que no.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Mr. Lopez, are you a U.S. citizen?
Sí.
Where were you born?
En Río Grande, Texas. Río Grande, Texas. Al Valle. Como es tipo.
In this case, sir, you were charged by indictment with 2 felony counts, the first of which is unlawful possession of a firearm by a felon. That is a 3rd-degree felony. Sir, to that charge, what is your plea, guilty or not guilty?
Culpable.
As count 2, the state jail felony of unauthorized use of the vehicle, what is your plea, guilty or not guilty?
Culpable.
Are you making each of your pleas freely and voluntarily?
Sí.
I will find you are making your pleas freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Your Honor, had these matters gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 13th day of October 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Sergio Lopez, hereinafter referred to as defendant, in count 1, did then and there, having been convicted of the felony offense of burglary of habitation on the 20th day of April 2015 in cause number 136-344-601010 in the 248th District Court of Harris County, Texas, intentionally or knowingly possessed a firearm before the 5th anniversary of the defendant's release from confinement following conviction of said felony. In addition, Mr. Lopez did then and there, having been convicted of the felony offense of burglary of habitation on the 20th day of April 2015 in the same cause, did intentionally or knowingly possess a firearm before the 5th anniversary of the defendant's release from supervision under community supervision or parole or mandatory supervision following conviction of said felony. In the second count, on the same day, the state would have been able, with the incidents having been committed the same day, the state would have been able to prove that beyond that anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Sergio Lopez, hereinafter referred to as defendant, did then and there intentionally or knowingly operate a motor-propelled vehicle, to wit, a Jeep automobile, without the effective consent of Brian Garcia, the owner thereof. At this point, Your Honor, the state would request that exhibits 1 and 2 be admitted to evidence.
No objection.
States 1 and 2 are admitted, states 2 being the 3914 disclosures. What's the plea agreement?
The state would recommend the defendant be sentenced to 3 years confinement in the Texas Department of Criminal Justice Correctional Institutions Division with no period of community supervision.
Mr. Huffman, is that the plea agreement on the 3rd degree?
No, Your Honor, it's 2 years.
Right. I showed 2 years also on the plea paperwork, Mr. Vandenberg.
Then I'm corrected.
Okay, and on the state jail? I showed 2 TDC and 12 months on the state jail felony.
I'm having a problem calling up. Yes, 12 months, Your Honor. That's correct.
Mr. Huffman, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Lopez, is that your understanding as well?
Sí, o sea, lo que quiero saber cuánto tiempo va a ser. 2 años o me van a dar 3 años, porque yo firmé 2 años.
So the offer is on 1 count, the first count, 2 years, TDCJ. The second count is a state jail felony. That is going to be 12 months in the state jail facility. Is that what you understood the plea agreement to be, Mr. Lopez?
Pues sí, pero quiero saber si, pues, como estoy firmando 2, no sé si voy a hacer 3 años, porque realmente pues viene siendo 3 años, pero yo firmo un 2 y llevo 9 meses. Me faltaría 13 meses, me faltarían aquí 14 meses para descargar el 2.
Mr. Lopez, I'm not asking for all the figuring out of days or dates. What I'm asking is that your understanding of what the agreement is? In other words, did you agree to 2 years TDC and 12 months state jail?
Sí.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Mr. Lopez, do you recall reviewing the trial court certification with your attorney and signing that document?
Sí.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In count 1, I will find you guilty of the offense of unlawful possession of a firearm by a felon, and I will sentence you according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. In count 2, I will find you guilty of unauthorized use of a vehicle, and I will sentence you there also according to the plea agreement to 12 months confinement in the Texas Department of Criminal Justice State Jail Facility. These sentences will run concurrent with one another, and you will receive credit for any and all time that you have served. Is there anything further, Mr. Vandenberg?
Not from the state, Your Honor.
Mr. Huffman, was there a question on terms of his time credit or was there something else? I can't hear you because you are muted.
No, o sea, lo que quiero saber si, o sea, si nomás va a correr juntos los 2 meses y los 2 años.
Yes,
Pero está bien, no hay pregunta.
yes, they are running concurrent with one another, Mr. Lopez, and you're receiving credit for time that you have served. As per my docket here, which might not be completely up to date till today, I'm showing at least 274 days credit.
No sé si puedo hacer una
Mr.
pregunta.
Huffman, anything else? let me ask your attorney first. Mr. Huffman, anything else?
Judge, we have nothing further.
Mr. Lopez,
But if Mr. Lopez has something else to say, that's fine. I mean,
Mr. Lopez, go ahead.
Es que tengo una orden de arresto en Dallas, o sea, no sé si me van a mandar para allá, lo que quiero es ya salir limpio para ponerme a trabajar. Y lo que quiero es ya, o sea, si me van a sentenciar ya también, lo que quiero es que corra todo para ya salir limpio de una vez.
I have no idea what Dallas is going to do. I'll refer you to your attorney.
Está bien.
just like we discussed, they've got the option to come pick you up. They've got a deadline. If they don't come pick you up in a certain amount of time, TDC will take you, but I expect Dallas to come pick you up.
There's nothing else holding him here, Mr. Huffman. I know, Mr. Vandenberg, you don't have access, but Mr.
Judge.
Huffman, nothing else?
Your Honor, I'm not showing a hold. I don't know if that detention, the order of, I don't know if the order for detention from Dallas has been lifted. But I'm looking right now and doesn't appear to be holding him.
I'm seeing a message here from our clerk, Mr. Lopez, that there is also not a hold. So that unless they're telling me there's another case, which there doesn't appear to be here, then there should be nothing else holding you here. Anything else?
Judge, just for the record, I can't predict what's going to happen in Dallas, and you know, we've made that pretty clear.
Anything else?
Nothing further.
Todo.
Mr. Lopez, anything else?
No es todo. Muchas gracias.
Thank you for your time. Thank you, Mr. Huffman. Does anyone else need the interpreter? Okay, who's next? Thank you, Ms. Hernandez.
Thank you, Your Honor.
Top of page 21, Judge.
Mhm.
Annex, may we have De La Vega, Mark De La Vega?
And he does not need an interpreter, right?
Correct.
Okay, thank you.
Thank you, Ms.
Thank you, Judge.
Have a good day. Who is here from probation on Mark de la Vega?
Miss Ibabe, Deborah Ibabe. Good
Ms.
afternoon. Your
Ibabe, I was reviewing this and preparing for the bond hearing today. I saw the bench warrant look like it was from December of 2022 and the driving was for June.
That's correct, Your Honor.
And he was reporting during all that time because he received, I think, a 20-day sanction for a driving offense where he was driving where he wasn't supposed to. This was all in 2022.
Yes, Your Honor. And he was attending the TAP program, Your Honor, and Officer Juan Miguel Ulloa advised him to take care of this warrant, bench warrant that it was issued. The problem that I noticed is that he was told so many times to take care of this, and then when he got transferred to me, I noticed the same thing, that he was active, so I refer him to go ahead and take care of the warrant. And he knew about that, and
Let me get on the record, Ms. Ibabe, because we're gonna get too far. I just wanted to make sure I saw the bench warrant accurately. Calling cause number 2019 0D00939, State of Texas versus Mark de la Vega. May I have announcement, please?
David Vandenberg on behalf of the state.
Daniel Avalar for Mark de la Vega, Your Honor. Good afternoon.
And Mr. de la Vega is appearing from the jail annex. My apologies, Ms. Ibabe.
from Deborah Ibabe to Probation Department.
We are scheduled for a bond hearing today. I believe he's in custody, Mr. Avalar, on a bench warrant. Is that right? He's been in custody for probably about 20, 25 days, close to that.
Ish, Your Honor. I'm wondering if he turned himself in, and I can proceed.
That I'm not sure.
No, he did. He was arrested here in the office when he reported at the office, at the inside office.
Okay.
All right, so I imagine, okay, so he's probably no bond, right? And so I was, as we were discussing off the record, reviewing the bench warrant because the name sounded familiar. And then when I read the case summary, it kind of jogged my memory a little more. And when I reviewed the bench warrant, the bench warrant was issued like around December 2022. Is that right, Ms. Ibabe?
That's correct, Your Honor.
And we had sanctioned Mr. De La Vega for driving. I think we had a previous hearing where it was found that he had a traffic ticket, and so he was driving.
So
And-
if he, sorry, Judge, if he was sanctioned, then shouldn't have that taken care of the warrant?
Well, that's my question, is if the driving that is listed as the basis for the bench warrant is the same conduct for which he received a sanction of jail time. He received some ACOP days. Let me get to the, in fact, I'm gonna have trouble since it's not just Carla to find this case summary. Let me see.
Your Honor, I need to notify the court that yesterday I did the El Paso Municipal Court check. It indicates that he had, after those sanctions back in 3/9/2022, well, the filing date on 1/6/2021. Another one, they came out two, and those are filed on 6/30/2022. There's pending offenses. And not
Okay,
the profit tickets, but those are dated 6/30/2022.
so what I want to find out, here I have the case summary now, is when he received, okay. So is the driving citation that is the basis of the bench warrant, is the date of offense June of 2022?
For the previous one, Your Honor, was 1/6/2021.
No, that's not what I'm asking. On the bench warrant, there's an affidavit that says you all want a bench warrant because he's driving without court permission. And if I'm not mistaken, it says a June 2022 date. Is that right?
I apologize for not having that information.
Let me see, where is the bench warrant on Mr. De La Vega?
Let me get that information for you, Your Honor.
Okay, the affidavit was filed December 8th, 2022. If I go to the affidavit, it
And the warrant was
says,
issued 12/9/2022. That's what I have in here.
well, the bench warrant was issued, but the affidavit says let's see, was driving thereafter on the 30th day of June, 2022. Mark De La Vega was driving without court's permission. So what substantiates that? Is there a separate citation? Like, how do we know he was driving on June 30th, 2022?
Correct.
And the reason is because, Your Honor, the previous officer was advised on 3/9/2022 that it was a search on the warrant, and the client did have this traffic citation for speeding that he was filing on 1/6/2021.
What was the date? March what?
March 9, 2022.
Okay, he did 20 days ACOP, 10-day original and 10 days due to driving and active traffic citations completed. He completed it from March 11th to April 11th, 2022. That's in
Yes.
the case summary.
Yes, Your Honor.
So my question is, was there a separate incident where he was driving after he got his ACOP that happened, I guess, on June 30th, 2022? That's what I want to know.
It was a positive UA, Your Honor, on 12/10/2021.
No. I'm asking about June 30th, 2022. Where is the documentation that he was driving on that day?
That makes sense, Ms. Ibabe?
Yes, I got it. I do apologize. I was just trying to get more information to this case.
No worries, we're just trying to clear it up.
Let me just get it for you.
ACOP in March.
sorry, Your Honor, the system is going super slow on my side.
Yeah, technology is a mess today.
Good afternoon.
Yesterday I was trying to work with it and Odyssey and Word did not help at all.
Good afternoon, Your Honor, if I may.
It's okay,
No,
Mr. Delivery. You're good.
no.
You're good.
Don't say anything yet.
What he probably will be trying to say is that he was advised that he need to take care of the warrant that happened back in 2022. And he was talking to the attorney and he was trying to finish school and he was working, because he explained that to me. So the
But the
warrant.
question is what makes the basis of the warrant?
I don't see, let me go back to the case summary.
Well, isn't there a violation notice or an affidavit or something?
I'm just trying to get it. Just give me a minute.
So a search that was done on July 17th, meaning yesterday, by I think Mr. Loa, found that there were 2 traffic citations dated June 30th, 2022.
That was done by me, Your Honor.
Oh, that was done by you?
Yes,
Okay.
Your Honor.
And
Those
so
are-
those have filing dates. Hold on a second. Those have filing dates of June 30th, 2022.
That's correct.
What I want to know, is it the same citation that we were notified of? In other words, is there a date of offense on the citation? Because a filing date can be different from when it actually happened.
The only thing that I was able to get into those filing citations, Your Honor, was the date of 6/30/2022. So it's a total different one from the previous one back into 1/6/2021. So there's 2 different ones, traffic tickets, I'm sorry.
So when we showed up in March of 2022, do you know the traffic citation numbers there?
Let me get it for you.
Right.
That was it.
De La Vega. De La Vega. Mark.
Because if it is a new one, then that's an issue, because he was sanctioned in March and then he picked up another one in June.
Right.
Problem.
I'm looking at a municipal court and he's not coming up.
I'm looking into the last court hearing back in 5/17/22, the notes by Mr. Ulloa is that they confirm.
All right. Well,
It
you
was
looked
just
at,
problems with the device that he's saying that he was not able to test Windows on this one. And it was
Was
just
he
basically on the device.
was he compliant with the device and probation after the bench warrant or no?
It looks like, yes, Your Honor, that he was in compliance. And he did have completed everything, all the classes and the community service hours. He's current on the fees and his reporting. It seems that he did better. And that he
Did
completed
he-
the top counseling.
Did he have the monitor the entire time?
Based on the notes of the previous officer, it seems, yes, Your Honor.
Okay, but did you, when you prepared this case summary,
Yes, Your Honor, I did.
did you check to see if he had, up until the point of his jailing, an alcohol monitor?
I did check, Your Honor, in the last report. Something talks a lot was. Provided by officer in here. Let me see.
Yeah, Judge, I just see a filing date of 6:30. I can't tell when the date of offense is.
Well,
It's
it
not
looks like
even-
it's a new citation because it's 2022. The previous citation was 2021.
No, March of 22, and then the
Yeah,
allegation.
we heard it in March of 2022, but that was for driving in 2021. And so this would have been after that.
I got you.
From the last report that we have, 4/6/2023 to 5/5/2023, we have no problems, Your Honor. And I
So-
did come in talks with companies, so I requested all the reports from them.
Okay,
Be added into in the system.
Mr. Avalar, you were set for a bond hearing. So what do you want?
Yeah, Judge, I mean, he's so close to being done, so it's kind of a shame that he's in custody based on the allegation of driving, Your Honor. I'm asking the court to set a reasonable bond so he can finish out his terms and conditions, Judge. I mean, there's not a whole lot I can say. I mean, if he's driving, I mean, that's a mea culpa. That's kind of a big deal for this court. But yeah, I'm asking that the court reduce his bond, just given the fact that he's just so close to being done.
So he
And I did
so
the
he-
check. I do apologize, Your Honor. I did check and he's eligible to obtain his driver's license.
Yeah, but it's not about having a driver's license, about following rules. Mr. De La Vega, you were in here in March or for March violations and you went to jail because you were not following the rules and you turned around and did it again. So, Mr. Avalar, well, is this a true third?
I believe it is
When does
Mr.
he term?
October of this year.
And 14/23, Your Honor.
So why not just keep him in jail until his probation expires and make sure that he's not disobeying rules?
That's August, September, October. That's 90 days.
That's 90 days. I mean, he got 20. He's been in 20 right now. What does he do, Mr. Avalar?
I don't have the answer to that question, really. I don't have the answer to that question, Judge. Mr. De La Vega, can you answer the court? What do you do for work?
Good afternoon, Your Honor. I am attending trade school. I am due to attend July 31st. I've been doing that. I've been doing construction. I have a mortgage I've been paying. I took a UA the day of my incarceration of my booking. I submitted an Intoxilog report the day before getting booked. What else can I say? I'm just asking some compassion from the court. If I could ask for that, Your Honor. I've been doing Uber since, since
Uber without a driver's license?
no, I mean, I've been getting Uber. I've had my license for
Oh.
about 4 years now. It's been current and standing. I had municipal court hearing yesterday. So they did dismiss 2 of the tickets and I did qualify for defensive driving for my speeding ticket, Your Honor. And I am trying to do the best that I can.
When'd you get your speeding ticket?
This was back in June 22nd, 2022. It was 3 months after.
So you're speeding when you're not even supposed to be driving. So that's why we have a bench. Well. In terms of the bond, Mr. Vandenberg?
Your Honor, I think you nailed it. The state objects to lowering the bond. Mr. De La Vega is admitted to violating the conditions. And not only does he violate the conditions, he violates the law even while he's violating the conditions. It's not a lot of time, Your Honor, for him in this matter. So we would ask that the bond not be lowered.
Okay, well, it's a no bond. Does he have resources for a bond, Mr. Avila?
Judge, I believe he does. I think he can afford 10,000.
No. So his bond is going to be 50,000 cash surety. The recommendation on the case summary
Mhm.
is a simple admonishment. I'm not there. We're having to go through this over and over again. If your client is, the court is satisfied with a 60 days ACOP credit for what he has.
60 days.
I'm sorry, 60-day jail commitment credit for what he has. He's got about 20 days.
I'll talk to him, Your Honor.
Okay. You're not set for anything else. So,
I'll go see him.
well, I don't think it's a situation where it's like, will he agree to? That's the order.
I got you.
Yeah,
Yes, ma'am.
that's the order.
And he has credit for about 20 some odd days.
I show him on my docket at 18. That was last week. So he's got, yeah, over 20.
23.
Thank you very much.
Yes, ma'am.
Alrighty.
Um,
Bobby, after he finishes his days, we need to ensure that he is continuing to be on the monitor.
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. Thank you very much.
Thanks, Judge.
Can
All
I
right.
just see, Your Honor?
Thank you, Ms. Ibabe. Who's next?
Thank you.
On page 20, Judge.
Mhm.
Annex, but we have Corona.
Mr. Ortiz, are you there? Is he here? No?
He was logged in, Judge.
It was long.
Hi there.
Call him, Mr. Wonderful.
In cause number
I'm sorry,
20,
did you just call me, Judge?
It's on Miss Corona.
in cause number 2020-0D0, 0443 and 2019-0D0, 5734, State of Texas versus Lizette Corona. Announcement of council, please.
David Vandenberg on behalf of the state on all causes.
Ruben Ortiz by Ms. Corona.
Lucia Mendoza from adult probation.
And we're set today for bond hearings and probation status hearings, Mr. Ortiz. I did make some inquiries because the mental health angle was one that we had been kind of going over and over again. Ms. Mendoza, and if you don't mind, Mr. Ortiz, I'd like to address this first because it might make the bond hearing unnecessary, but I will hear it if you'd like afterwards, if we don't come up with a solution. Ms. Mendoza, the update, it looks like we have possibly some screening appointments to get her on the MHI caseload. She wasn't previously on it. I think probation's request or suggestion was if we secure a date within the 10 days time that she has the medication, that we can have some type of continuity in terms of any potential treatment. But Mr. Ortiz, we would still be pending an assessment in terms of level of care. It wouldn't assure that she's on the mental health caseload until they do the assessment. I can tell you, Miss, for my purposes, Miss Corona has been in custody so long. And I do believe her issues are somewhat based in her mental health treatment, that I'm agreeable with that proposal to release her with a scheduled appointment date, continuing meds, and having her screen. Hopefully we can get her in the mental health caseload. What I'll tell you is if she doesn't qualify, we're going to need to come back and check status on her. But they haven't evaluated her yet, Mr. Ortiz, and I think we've come back at least twice to get that done.
Yes, Your Honor.
Ms. Mendoza, although now I'm thinking there might have been a jail screening. In any event, I think that was part of the plan. Or Ms. Mendoza, go ahead.
I'm sorry, Your Honor. For her to get services from Tacoma, she needs to be released.
Right.
And yes, before we even have her screened for the mental health unit. But she has been diagnosed, she's been provided medication, and we just need a date so we can be within those 10-day period of medication that the jail provides, so we don't lose her and be on top of a follow-up with her appointment with the EHS.
Mr. Ortiz, is she going to be with mom and dad upon release?
She's nodding yes.
Either mom or is either dad.
Mom. She's always, I think she's with mom. Or both. Which one? You know what? I can't remember anymore.
Hmm.
Where are you gonna live, Miss Corona?
He's my dad.
Dad. You're right. Ms. Mendoza was correct with dad.
All right, then, then I'm gonna order Miss Corona, we don't have any new cases, right? There's nothing else holding her. I'm gonna order that Miss Corona, be released to be screened through Takumi to assess if there are any mental health services that need to be addressed. Ms. Corona, you are still subject to every condition of your probation. You messed up last time, and if you mess up another time, Mr. Ortiz has done everything in his toolbox, utilized everything in his toolbox to help you, but you are not helping yourself. If I find out you've missed one appointment, you're not complying in any way, you're coming back. Ms. Jasmine, give me an order on her release with the language. Well, I don't even think there's going to be language because there's no conditions other than the modification on Takumi. Or Ms. Mendoza, what other language do we need?
For her to be released to the streets, Your Honor, and then we just follow up with it. If she qualifies, we follow up with the modifications.
Okay. There also, of course, will be the restriction she's representing. She's staying with dad, has to stay there, not go anywhere else. We're going to come back in 30 days. Mr. Ortiz.
Thank you, Judge. Thank you very
for
much.
continuing to assist the court on this case.
You're
Your
very
Honor,
welcome, Judge. Thank you.
Oh, I'm sorry. Your Honor, is this going to be released today?
Yes.
Okay, so I can contact.
If they can, I don't know if they can, because by the time I get the order and sign it, it's going to be a long day.
No,
It's gonna
yes,
be a long day.
of course. I just want to make sure so I can contact Ms. Roxanne Garcia Juarez so she can schedule her an appointment immediately as soon as we can.
Ms. Corona, I don't know if you're just really happy because you're about to make changes in your life. But I hope you're taking this seriously, because I am not playing with you.
Yes, Your Honor.
All right. Ms. Mendoza, we'll get her squared away. I need to know immediately if we have any issues with her.
Yes, yes, and Ms. Corones, I conducted a jail visit, Your Honor, and she was given instructions for her to, once upon release, she needs to report to my office immediately in person.
Okay, if that doesn't happen, just send me a bench warrant.
Yes, Your Honor.
Thank you very much. Thank you, Mr. Ortiz. Is there anything else?
Judge. Nothing further, Your Honor. May we be excused?
You may. Have a good day.
Thank you.
But
Bye,
yes,
everyone.
Your Honor.
Yes, ma'am. Thank you, Ms. Mendoza.
Thank you. Have a nice day.
You too. Who's next?
Middle of page 22, Judge.
Mhm.
Annex, may we have Perez Guillen?
Is this one an interpreter or no?
Don't recall, Judge.
No? Okay. Ready, Mr. Vasquez? Does your client need an interpreter?
No, Your Honor.
Okay, let's get started.
In cause number 2021-0D02039, State of Texas versus Gilliam Perez. Announcement of council, please.
David Vandenberg on behalf of the state.
And Joseph Vasquez representing Mr. Jean Gilliam Perez, and we're ready, Your Honor.
And oh, I'm sorry, go ahead. Thank you, Ms. Mata. Mr. Perez, did you sign and agree to this proceeding being done over Zoom rather than in person?
Yes, Your Honor, I did.
Okay, so let's go ahead and get started with your plea today. I need to swear you in. Please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth? I didn't hear you if you said something.
Your Honor.
Do you swear to tell the truth and the whole truth, sir?
Yes.
Thank you very much. You can put your hand down. It's just a little hard sometimes. The audio isn't great. Thank you, Mr. Perez. Sir, would you state your name and date of birth for the record?
John Gilliam Perez, October 7th, 1994.
Sir, are you the same individual who on April 26, 2022 pled guilty to the offense of possession of a controlled substance in penalty group 1 at an amount less than 1 gram and was given 1 year of deferred adjudication under 1244B? Are you that same individual?
Yes,
Mr. Vasquez, do you waive formal reading of the motion to adjudicate?
I do, Your Honor.
And Mr. Vasquez, any reason to believe your client is not presently competent to proceed?
No, Your Honor.
Mr. Perez, have you ever been found mentally incompetent by any court?
no,
Ever been examined by a doctor or psychiatrist who have ever found you mentally ill?
no,
Mr. Perez, I did receive documents marked as States Exhibits 1, 2, and 3, the stipulations and waiver in this case. Do you recall reviewing those with your attorney and signing them?
yes, I do.
Do you understand everything contained within that document?
Yes, Your Honor.
Are you freely and voluntarily waiving the rights explained in the documents that you signed? Do you understand? I'm sorry, what was that?
Yes,
Okay. You understand that by signing those documents, you're giving up certain constitutional rights?
yes,
Do you understand that you're making a judicial confession?
yes,
Do you understand that on your plea of true and all reasonable probability, I will find the allegations in the state's motion to be true, and in all reasonable probability, your supervision will be revoked? Do you understand that?
yes, I do.
And as to that motion, do you wish to enter a plea of true or not true?
True.
Are you doing so because the allegations are true and for no other reason?
Yes,
Mr. Vandenberg, is there an agreement in this case?
Yes, Your Honor.
What is the agreement?
6 TDC.
I'm sorry?
This is a
Class A
misdemeanor.
misdemeanor?
Let me make sure this is the correct case.
I had down 365 days. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
Mr. Perez, is that your understanding of the plea agreement? 365 days in the El Paso County Detention Facility. This is a misdemeanor.
yes,
Okay, I will admit states 1, 2, and 3 into evidence. The court will take judicial notice of all the documents in the district clerk's file in this case. Mr. Perez, based on the evidence presented here today and on your plea of true, I find there is sufficient evidence to support the allegations in the motion and make a finding now that you are indeed guilty and that the allegations are true. The judgment in this case is hereby amended from 1 year deferred adjudication probation to 365 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Mr. Vandenberg?
No, Your Honor.
Anything, Mr. Vasquez?
No, Your Honor. Thank you.
Thank you very much. Good luck to you, Mr. Perez.
thank you. Have a good day.
You too. Who's next?
Second on page 21, Judge.
Mhm.
Annex, may we have Hernandez, Angel Hernandez?
Coming up.
Am I being excused, Your Honor?
Yes, thank you, Mr. Vasquez.
Thank you, Judge. Bye.
Hmm.
We'll see. We'll see.
This is Hernandez.
Good afternoon.
Good afternoon. Go ahead, Mr. Meadowful.
In cause number 2022 0D04194, State of Texas versus Angel Gabriel Hernandez. Announcement of council, please.
David Vandenberg on behalf of the state.
Mr. Macias, you're muted.
Good afternoon, Judge Perez.
Good afternoon.
Francisco Macias for Angel G. Hernandez. We're ready to proceed on a plea, Your Honor.
And Mr. Macias, do you see your client appearing from the bail annex?
Yes, Your Honor, I do.
Mr. Hernandez, I did receive plea paperwork regarding your plea today. I need to ask you, have you consented to do this over Zoom?
Yes.
Okay, in order to get started with your plea, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth? I didn't hear you, Mr. Hernandez. I don't know.
Step forward.
Maybe if you can get closer, I'll be very frank. You can put your hand down. Everything with respect to the internet has been really strange lately, so I may ask you to repeat yourself. Also, I will tell you, if there's something you don't hear us saying, please get my attention. We'll stop and repeat anything you don't get. Okay, Mr. Hernandez?
Yes, Your Honor.
Okay, yeah, you might need to speak a little louder too. All right, sir, would you state your name and date of birth for the record? Mr. Hernandez, if you're talking, I can't hear you.
Angel Gabriel Hernandez.
Date of birth?
1097.
Mm-mm.
1097.
Yeah, it's cutting out. Maybe you get a little bit closer.
1097.
Okay, that's good. Don't move from there. Mr. Hernandez. As I mentioned, I did receive documents reference your plea, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Hernandez, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes.
Did you understand everything contained within that document?
The probation?
The plea papers. So that long multiple page document, did you understand everything therein?
Yeah.
Mr. Macias, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, I have.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I believe he does. We should have scratched out the deferred probation portion on either page 4 or 5. He initialed it. He knows that he is not receiving deferred probation, I believe. Or is he?
No, he is not. It's 6 for
Right.
6 straight.
That's
Yes.
correct.
Okay. Mr. Hernandez, are you satisfied with your attorney's representation of you?
I can't really do nothing about it. Well, yeah. Well, what do you mean by straight?
Are you satisfied with your attorney's representation of you?
Yes.
Mr. Macias, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor, I believe he's competent to enter the plea.
Mr. Hernandez, have you ever been found mentally incompetent by any court?
No.
I need okay. Mr. Macias, I'm sorry, Mr. Hernandez, have you ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay, so based on your testimony, your attorney's representation, and my observation of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Las Cruces, New Mexico.
Okay. In this case, you were charged by indictment with a second-degree felony of possession of a controlled substance and penalty group 1 or 1B in an amount between 400 and 200 grams. The range of punishment there is anywhere between 2 years to 20 years confinement and a $10,000 fine or up to 10 years of probation. Sir, to that charge, what is your plea, guilty or not guilty?
No contest.
How
Can I
about a
ask-
guilty plea, just straight up?
Mr.
Yeah, ma'am.
Hernandez, are you prepared to go forward with your plea today?
Well, yeah, well,
If you're not prepared to go forward with your plea today, give me a second. It looks like you were set for jury trial in May and then we set you for a plea. Mr. Hernandez is not going to give me any heartache if you are not wanting to go forward with your plea, but I need to get you new settings. I can try, if you have questions for your attorney, to give you the opportunity to do that. I just don't think I can do that until the end of this docket, which would be closer to 5 p.m. So you tell me, you want to go forward or no?
Yeah,
Is that a yes?
yes,
Okay, as I mentioned, in this case, you were charged by indictment, possession of a controlled substance in penalty group 1 or 1B in an amount between 4 and 200 grams. That charge, sir, what is your plea? Guilty or not guilty?
all content versus
I will not accept a no contest plea. You
guilty,
either say you're guilty or you're not guilty.
and, guilty,
Mr. Hernandez, are you, do you need to speak with your attorney further? I mean, you've given me 2 different pleas today.
what do you mean? I agree.
Well, I'm not satisfied that you're wanting to plead guilty. You've told me a couple of different things and you're moving side to side.
I said guilty,
I'm gonna, are you making your plea freely and voluntarily?
yeah,
Not yeah, yes or no? Mr.
Yeah.
Hernandez,
yes, ma'am,
are you pleading guilty because you are guilty and for no other reason?
well, nothing was on my possession, but I just wanna get out of here.
Yeah, no. Mr. Macias, I'm gonna go ahead and reset this for a final hearing plea deadline in 30 days. Was there anything outstanding in this case?
Not that I'm aware of, Your Honor.
No, Your Honor, let me go talk to him and let's see if we can schedule this plea a little
Sure.
bit sooner than that.
Sure, I do apologize. The docket is
No, no,
beyond full today. Otherwise, I would allow you to do that now on the breakout room, but I'm going to reset this for a final hearing plea deadline in 30 days. If it becomes more clear and you want a plea hearing before that, just let us know as soon as you can.
I will, Your Honor. Thank you very much.
Thank you, Mr. Hernandez. We're adjourned on your case. We're going to get you reset. Thank you for your time, Mr. Macias. Who's
May I be
next?
excused, Your Honor?
May, take care.
Thank you.
Page 25, Judge. Annex, may we have Hinojosa?
Let me look at all these there on our list. You know, so what's the first thing?
Andrew?
And we don't know.
It's Hinojosa with a Y. It's not regular Hinojosa.
No, Hosa. Sorry about that, Your Honor, it's with a Y, you're.
Yeah, it's different. Are we going to use anyone else in the courtroom, Adolfo?
No, Judge, I'll kick him.
Okay, I'll remove him.
Thank you for all your help. You're welcome, sir.
No, what's up?
Mr. Solis, are you there?
I am here.
Thank you, Mr. Solis. Go ahead.
In cause number 2022-0D05828 and 2022-0D03898 and 2022-0D03897, State of Texas versus Andrew Hinojosa. Announcement of council, please.
David Vandenberg on behalf of the state and on all 3 causes, Your Honor.
Eduardo Solis or Mr. Andrew Hinojosa, we're ready.
Mr. Hinojosa, are you, I did receive paperwork regarding your plea today. Are you in agreement to conduct this plea over Zoom rather than in person?
Yes, go.
Okay, let's go ahead and get started. Raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
Andrew Hinojosa, 7182.
Mr. Hinojosa, as I mentioned, I did receive paperwork.
Just a minute, Judge, just a minute, Judge, just a minute.
Sure.
Thank you, Judge. Ready?
I did receive paperwork in each of these cases indicating that you wish to plead guilty. The first document I reviewed for each case was marked as State's Exhibit number 1. Those are the plea papers for each of the cases. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Hinojosa, do you recall reviewing the plea papers with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Solis, have you had more than 10 days to prepare defenses in each of these cases?
Yes, we have, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
You believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
I believe he has.
Mr. Hinojosa, are you satisfied with your attorney's representation of you? Was that a yes? Yeah, the audio keeps cutting off. Mr. Hinojosa, if you'll speak up a little bit, please.
Yes, ma'am.
Thank you. Mr. Solis, any reason to believe your client is not presently competent to enter his pleas?
No, Your Honor.
Mr. Hinojosa, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, ma'am.
I need you to speak louder, Mr. Hinojosa.
Yes, ma'am.
Okay, where were you born?
San Angelo, Texas.
Okay. In cause number ending 5828, you are charged with the first count is a state jail felony offense of possession of a controlled substance in penalty group 1 or 1B in an amount less than 1 gram. Sir, to that charge, what is your plea, guilty or not guilty?
Guilty.
In count 2, it's tampering or fabricating physical evidence with intent to impair. That is a 3rd-degree felony. Sir, what is your plea, guilty or not guilty?
Guilty.
In cause number ending 3898, you were charged with the offense of possession of a controlled substance in penalty group 1 or 1B in an amount between 1 and 4 grams. That's a 3rd-degree felony. What is your plea, guilty or not guilty?
Guilty.
Was that, let me verify, Mr. Solis, I don't know if Mr. Vandenberg has the plea papers. In 3898, was he pleading to the 3rd degree or was it to a state jail felony?
State jail, 6 months.
Okay, so it was less than 1 gram, correct?
Correct.
Okay, Mr. Hinojosa, I need to make a correction. In cause number ending 3898, it is a reduction. It is a lower offense, a state jail felony, possession of a controlled substance in penalty group 1 in an amount less than 1 gram. Again, to that charge, what is your plea, guilty or not guilty?
Guilty.
In cause number ending 3897, it's theft of property in an amount between $2,500 and $30,000. What is your plea?
Guilty.
Are you making all of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
One moment, Your Honor. I'm just getting the indictments right now. Your Honor, in cause number 2022 0D03897, had this matter gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 8th day of September 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Andrew Hinojosa, hereinafter referred to as defendant, did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a Volkswagen motor vehicle of the value of $2,500 or more, but less than $30,000 from Digital Ceramics or Edward Perez, the owner thereof, without the effective consent of the owner and with intent to deprive the owner of the property. And it is further presented in and to said court that prior to the commission of the aforesaid offense, hereinafter styled the primary offense, on the 23rd day of July 2002, in cause number B020500S in the 119th District Court of Tom Green County, Texas. The defendant was convicted of the state jail felony of failing to comply with sex offender registration, and is further presented in and to said court that prior to the commission of the primary offense on the 16th day of October 2019 in cause number 2018-0D00758, count 2 in the 168th District Court of El Paso County, Texas. The defendant was convicted of the state jail felony of evading arrest with defendant with a previous conviction. In case number 2022-0D05828, had this matter gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 28th day of September 2021 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Andrew Hinojosa, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in the amount of less than 1 gram. And in the third and final cause, which is 2022-0D.
Well, wait a minute. There's 5828 has two counts.
Okay. You are correct. Thank you. Count 2 on that cause number, the 20th day of September 2021, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Andrew Hinojosa, hereinafter referred to as defendant, did then and there with the specific intent to commit the offense of tampering with physical evidence, do an act, to wit, throwing a glass pipe containing black and white residue, which amounted to more than mere preparation, that tended but failed to effect the commission of the offense intended. Back to 3898. Does that suffice, Mr. Solis?
I'm sorry.
Does that suffice for the previous cause number? Both counts?
Those are 2 counts, correct?
Good, thank you. In this final one ending in 3898, had this matter gone to trial, the state would have been able to prove that on or about the 8th day of September 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Andrew Hinojosa, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in an amount of 1 gram or more, but less than 4 grams. And it is further presented in and to said court that prior to the commission of the aforesaid offense, hereinafter styled the primary offense, on the 26th day of October 2005, in cause A050960S, in the 51st District Court of Tom Green County, Texas, the defendant was convicted of the felony offense of failure to comply with the sex offender's duty to register as civil. And it is further presented in and to said court that prior to the commission of the primary offense and after the conviction in cause number A as an alpha 05096S was final, the defendant committed the felony offense of possession of a controlled substance, penalty group 1, of an amount between 1 and 4 grams, and was convicted.
Mr. Vandenberg, are on those enhancement paragraphs, I'm assuming, no, Mr. Solis?
Yeah, I didn't handle those underlying cases when he first pled to them, but obviously they abandoned them because the plea right now is 6 months state jail on both those.
Right.
You're correct, Your Honor. So those, we won't plead true to that. We will
Right, so in terms of the enhancements paragraphs, Mr. Vandenberg, I'm assuming you're abandoning those.
Yes, we are, Your Honor.
Okay, so are you asking to admit anything?
Yes, at this point, the state would ask that the exhibits 1 and 2 be admitted into evidence, Your Honor.
Any objection, Mr. Solis?
There are a total of 3 exhibits, Your Honor, just 3 causes. We have no objection.
So as to each cause, there are states exhibits 1 and 2, 1 being the plea papers and the 2 States Exhibit 2 being the 3914 disclosures, states 1 and 2 are admitted without objection in each case. What is the rec?
Your Honor, in first matter,
Is it 6 months on all the state jail felonies and 2 years on the 3rd-degree felony?
Correct.
yes, Your Honor.
Mr. Solis, that's your understanding of the plea agreement.
That is correct, Your Honor.
Mr. Hinojosa, is that your understanding as well? I'm sorry?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. It is a one-page document that explains your appeal rights. There is one for each case. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Hinojosa, are you able to hear me okay? Okay. Did you review the trial court certification with your attorney and sign those?
Yes, ma'am.
They were signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2022-0D05828, I will find you guilty of the offense of possession of a controlled substance in penalty group 1B in an amount less than 1 gram and sentence you according to the plea agreement, 6 months confinement in the Texas Department of Criminal Justice State Jail Facility. As to count 2, I'll find you guilty of tampering or fabricating physical evidence with intent to impair and sentence you as well to the according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. As to cause number 2022-0D03898, find you guilty of possession of a controlled substance in penalty group 1 in an amount less than 1 gram and sentence you to 6 months in the state jail facility. And in cause number 2022-0D03897, find you guilty of theft of property in an amount between $2,500 and $30,000, 6 months confinement in the state jail facility. All sentences will run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Mr. Vandenberg?
No, Your Honor.
Mr. Solis?
No, Your Honor. Thank you.
Thank you very much for your time. Good luck to you, Mr. Hinojosa. Who's
Thank
next? You're
May I be
excused, Mr. Solis.
Thank-
Have a good afternoon.
Thank you.
Page 18, Judge. Annex, may we have Alvarez, Christopher Alvarez?
Coming out.
Go ahead.
In cause number 2021-0D01337 and 2022-0D00253 and 2022-0D00792 and 2021-0D00772, State of Texas versus Christopher Ray Alvarez. Announcement of council, please.
David Vandenberg on behalf of the state for all 4 matters.
Rick Huffman on behalf of Mr. Alvarez.
Okay, we're set for final judges conference. Are we on track for our special setting jury trial on August 3rd and 4th?
Yes, Your Honor, the state is.
Defense is ready, Judge.
Okay, anything we need to go over? I think we had previously discussed which case we were intending on going on first, and that appears, at least from my notes, to be 1337. Is that right?
Yes, Your Honor.
That is my understanding as well.
Okay, we have our final hearing plea deadline on July 25th. Is there a rec? Is there an offer?
There has been an offer in this, Your Honor, but it's not
Yes.
on the CAN access portal.
Okay,
Judge, the
Yeah.
offer was probation.
Okay.
That offer was relayed to Mr. Alvarez.
okay,
Rejected.
and rejected. Okay. And so I guess I'm just asking whether we need that final hearing plea deadline setting of July 25th.
Can't hurt.
We'll see on the 25th. It's at 10 a.m. though. It's not at 3. So do you want it at 3?
Whichever's more convenient for the court. We'd
Let's go
appreciate
ahead
it.
and do it at the 3 p.m. setting in the event there is a reason for that setting. Okay,
Thank you, Judge.
all right. Thank you. Who's next?
Bottom of page 19, Judge.
Mhm.
And annex, may we have Conde, Jorge Conde?
Go ahead.
In cause number 2022-0D05268, State of Texas versus Jorge Conde. Announcement of council, please.
David Vandenberg on behalf of the state.
Rick Huffman on behalf of Mr. Conde.
And Mr. Conde is appearing remotely from the jail annex. We are scheduled for a final hearing plea deadline. Mr. Vandenberg, what's the rec?
The rec is 13 TDC, Your Honor.
Was that 1-3-13?
1-3, yes.
Okay.
And Your Honor, I actually forgot to talk, I went to the annex yesterday. I meant to relay that offer. I don't remember if I've conveyed that offer to Mr. Conde. I was really hoping I could sweeten that offer up a little bit before I went and spoke to him. Judge, can we come back tomorrow and bring him in person? Would that be a possibility? The 13 is a lot. I mean, it's a lot, but I've got to convey it. I've got to make a counter.
Is this new today?
No,
The rec is not new.
the rec's like a couple weeks old, I think.
Yeah.
When do you know when you conveyed the rec, Mr. Vandenberg?
No, I don't have that, but it's been there for a bit at least.
I think at the last hearing, it was reduced down to 13 from 18.
Okay, but is this DWI number what?
hmm.
And was his last one 16 TDC?
The last one was 10. And
I
he's on
believe that's
parole.
correct. I think he had, this is above, the current rec is above the last number he served in TDC.
Okay. Well, I mean, we have trials set on Friday.
Well,
Is there anything outstanding?
no,
I don't believe so.
we've got.
Are you otherwise ready, Mr. Huffman?
Yes, but I'd like to negotiate. I'm not thrilled about going to trial at this point. It's a habitualized case, and to be frank, it's a difficult case.
It's his 7th DWI?
That I do not know.
I'm not going to reset anything, Mr. Huffman. You have the rec. You need to go talk to your client. If I see plea papers, we can get you a plea setting.
So I'll let the court know tomorrow afternoon. Would that be fine?
That's fine.
And I'll email Mr. Vandenberg and maybe sweet talk him and reduce him down a little bit.
Yeah, you're a sweet talker there, Mr. Huffman.
All right. Mr. Marufo, make sure we send Mr. Huffman jury sheets on Mr. Conde. Okay.
Yes, Judge.
Thank you. All right. Who's next?
Bottom of page 20, Judge. Annex, may we have Davila, Eduardo Davila?
Hey, it's our new Mr. Hernandez. All right. Oh, no, sorry, that's Mr. Hernandez, not mine.
It's Mr. Hernandez, and it'll be Miss Payan from now on at the 210, Your Honor.
I understand.
We're working on this together, Judge. Mr. Hernandez keeps trying to divorce himself from this, but he's
I don't know why he's done so much work. Let's go ahead
That's
and,
what I'm saying. He's done all the work. He knows it. It's his plan.
all right, let's call it.
in cause number 2022-0D00735 and 2021-0D02285, State of Texas versus Eduardo Davila. Announcement of council, please.
David Vandenberg on behalf of the state on both causes.
Edward Hernandez and Edie Payan on behalf of Mr. Eduardo Davila, Your Honor. And I'm not bailing on this case. I'm gonna stay with the client as well. But Ms. Davila, because she's in the 210, I'm sorry, Ms. Payan, because she's a 210, will have more day-to-day contact. Your Honor, on behalf of Mr. Davila's case, we pulled the 300 some odd pages of legal records from his civil injury case 40 years ago. It's our understanding now that based on what's in those records, that his treating physician is deceased, but our expert believes we can get the records if his practice was transferred to somebody else or sold to somebody else. So we are trying to track down the medical records that relate to the injury our client suffered. Clearly, this is an insanity defense case, Your Honor. We will speak with opposing counsel. We've been speaking with Ms. Elizalde as well, and I started speaking to Mr. Vandenberg. Again, this is the situation in which our client, at the age of 5,
I remember. I just want to
Right.
know, we're set for trial August 18th. If you all are not going to be at a point to go, I want to know, as soon as possible.
Your Honor, we just want to get the admissible records, so we do not foresee going on the 18th. But I don't want to leave Mr. Davila just in there. We would request a bond, we'll file and request for a bond hearing in the meantime. But we're trying to get the records that we can actually use in court in an insanity defense, and working with the state to see if we can reach an agreement.
Mr. Vandenberg, is there an offer in this case?
Yes, Your Honor, on both of these. On the theft of property, 2285, the rec is 5 TDC. And on the arson, case ending in 735, the rec is 20 TDC.
All right, so I will see you all at the final hearing plea deadline. If you anticipate your request for continuance, please just confer if it's not opposed. If you put that in there, and then if you want your bond hearing, file your motion and request your hearing. We can do it on the final hearing plea deadline date, okay?
Yes, Your Honor. And when I was going over the facts, Your Honor, it's only because I understand Mr. Vandenberg is not as familiar with this case as other attorneys have been. But we'll bring him up to speed, Your Honor, and we do anticipate a continuance, but we'll also request a bond hearing in the meantime.
Thank you very much.
Mr. Davila, I'm going to visit you, so I'll see you either this week or next week, and I'll try to take Ms. Payan with me, okay? So you can meet her and you'll meet both attorneys on your case. Okay, thank you, Your Honor.
Thank you for your work. Yes, sir. Thank you very much. Who's
Thank
next?
you.
Thank you.
Bottom of page 24, Judge.
Mhm.
Annex, may we have Vargas, Samantha Vargas?
Good night, Your Honor.
Is someone, Mr. Huffman or Mr. Shelley, or is someone handling Samantha Vargas? Mr. Shelley, that's you? Okay.
In cause
go.
number 2022-0D04708, State of Texas versus Samantha Vargas. Announcement of council, please.
David Vandenberg on behalf of the state.
Frank Shelley, on behalf of Ms. Vargas, defense is ready.
And Ms. Vargas is appearing remotely from the jail annex. Ms. Vargas, can you hear me okay? Okay, I'm gonna need you to speak up quite a bit louder.
Yes, ma'am.
Okay. I have you scheduled for a plea today. Are you consenting to do this over Zoom rather than in person?
Yes, ma'am.
Okay, to get started, I need to swear you in. Raise your right hand, please. Ma'am, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Please state your name and date of birth for the record.
Anto Vargas, 52797.
Ms. Vargas, as I mentioned, I did receive paperwork indicating you wish to plead guilty in this case. The first document is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Vargas, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Shelley, has your office had more than 10 days to prepare a defense in this case?
Yes, Judge.
And did you explain the plea papers to your client?
Mr. Rivera did, yes, Judge.
Did he convey to you that there was an understanding of all the admonishments, rights, and consequences of giving up these rights by entering her plea today?
Yes, Judge.
Ms. Vargas, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Shelley, any reason to believe your client is not presently competent to enter her plea?
No, Judge.
Ms. Vargas, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representation, and my observations of you, I'm going to find that you are competent to enter your plea today. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Paso, Texas.
In this case, ma'am, you were charged by indictment with the state felony offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. Although I understand through negotiations, we're pleading it to a misdemeanor of the same offense under 1244B. Okay, that's a Class A misdemeanor. So to that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Ma'am.
I will find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor. Had this matter gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 22nd day of February 2021 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Samantha Vargas, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in an amount of less than 1 gram. At this point, Your Honor, the state would request that exhibits 1 and 2 be admitted into evidence.
No objection.
Without objection, states 1 and 2 are admitted. What is the plea agreement?
Your Honor, the state recommends, I'll get to this, 1 moment. 60 days confinement in the El Paso County Detention Facility with no period of community supervision and credit for time served.
Mr. Shelley, is that your understanding of the plea agreement?
Yes, credit for time served is my understanding, Judge, yes.
Okay, Ms. Vargas, is that your understanding as well? Was that a yes?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Ms. Vargas, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea, and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. And I will sentence you according to the plea agreement and in accordance with 1244B of the Texas Penal Code to 60 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. At least at the time of the printing of my docket, you have 84 days credit. You probably have more than that. Or anything further, Mr. Vandenberg?
Not from the state, Your Honor.
Mr. Shelley?
Nothing further, Judge.
Thank you very much. Good luck to you, Ms. Vargas. Mr. Shelley, you are excused.
Thank you, Judge. Have a good day, everyone.
You too. Who's next?
Judge, I believe we're done. I mean, I didn't hear what was going to happen with Mr. Parra's clients, Buenrostro and Tari.
So Buenrostro, the only one I pushed back was Tarin because of there's too many plea papers for me to review.
Yes.
So in a short period of time, but Buenrostro, let me see. That was a probation case, right?
Yes, Judge.
2 probation and 1 new case. Has she, Ms. Guerra, are you here on Buenrostro?
I am, Judge.
Okay, so I would say for now, we can get off of YouTube if we don't